All right, everybody. The recording has started, which means we're officially underway. It's really nice to have you all here. We're so glad you could join us for the official kickoff event of Student Press Freedom Day 2023. If you missed it, my name is Danielle Dietrich. I know it doesn't say in my Zoom square, but I am the digital strategist over at SPLC. I'm also the coordinator for Student Press Freedom Day. So very excited to meet some new faces, see some faces I recognize here tonight. I'm going to run through some intro stuff to give people a chance to sort of join in, and then we will get right into it. First of all, thank you to a couple of folks who are helping me out tonight. First off is William, who I mentioned, who is one of our student co-chairs for Student Press Freedom Day. You will see him in a minute. I just realized, let me be vain and spotlight myself. Hi. So William is one of our student co-chairs. We also have a couple of our other co-chairs here tonight. They're a really great group of students who are leading the way for Student Press Freedom Day. Dan Formansky, who works very closely with me on coordinating Student Press Freedom Day. And then, of course, the one and only Mike Houston, who many of you probably already know. As I mentioned just before the recording, he's on PBS NewsHour tonight. So sort of a big celebrity. He's rolling his eyes at me. But he's really great. He's our senior legal counsel and the person who is often picking up the phone for the legal hotline. So a little bit about the Student Press Law Center. We were founded in 1974, and we work to promote, support, and defend the First Amendment and free press rights of student journalists and advisors. We're the only national nonprofit here in the US that is specifically working to protect the legal rights of student journalists. We do that through a ton of different ways, including the legal hotline that I mentioned. If you don't know, make sure you know. The hotline is always here when it comes to issues of censorship. Maybe you have questions about media law, that could be copyright, FOIA, anything related to student media law. We are here to help you directly through that hotline. So don't hesitate to reach out. We also do some great advocacy work when it comes to new voices and trying to change the media law landscape for student journalists on a state-by-state basis through grassroots advocacy. So if you're really interested in this conversation, there's a good chance you might be interested in trying to improve student press freedom in your state. We'll talk a little bit more about what that actually means in the presentation tonight and ways that you can get involved. So look out for that. And then, of course, I'm digital strategist. So I must tell you to follow us on social media. So on Twitter, we are at SPLC for as long as there is a Twitter. And then on Instagram, it's at Student Press Law Center. I'll drop those links in the chat in just a minute here. I mentioned tonight's workshop is part of Student Press Freedom Day programming. The day itself is going to be February 23rd, but we've got lots and lots of programming leading up to the day, which is why we're starting here on December 1st. Student Press Freedom Day is a time when we really bring together the whole student media community. We are building up the incredible work that you're doing, commiserating over the challenges that you're facing, and trying to take action to protect and restore the First Amendment rights of student journalists. So the perfect way to sort of kick that off is with a crash course on student press freedom, which is what we're here for tonight. So with all of that intro, I'm going to go ahead and quickly pass it along to William, who I mentioned earlier. He can sort of introduce himself and hopefully get you all involved in Student Press Freedom Day this year.
Thanks, Danielle. My name is William Tong. I'm a freshman at Northwestern and studying journalism, hopefully also legal studies and computer science. And then I'm also a Student Press Freedom Day co-chair for 2023. The theme for SPFD this year is bold journalism and brave advocacy, because it takes courage to be a student journalist, and it takes even more courage to stand up for your rights when press freedom is being threatened. I'm sure a lot of people here have personal experiences with that, and you're going to figure out, at least hopefully through tonight's presentation, how you might be able to defend your rights. And at the same time, I hope you'll join us over the next couple of months leading up to Student Press Freedom Day, and there are a lot of ways to get involved. One thing you can do right now is apply for an op-ed coach, and if accepted, you'll work one-on-one with a professional journalist who can help you write and place an op-ed at a local or even national publication. And like everything the Student Press Law Center does, It is totally free. Danielle's going to drop a link in the chat for that in just a second. In January, we're also going to have 2 fan favorite Student Press Freedom Day trainings, an op-ed boot camp that's available to everyone. You don't have to be with a coach to sign up for that. And then a training about how to be a spokesperson for Student Press Freedom. Danielle's also going to send links in the chat for that as well. And then if you're interested in more stuff, you can go look at studentpressfreedom.org. I will also add, in addition to the legal hotline, there's also an online form you can fill out if you're like telephone shy or whatever. I've used that before, super helpful. The Mike Heaston himself will literally come and talk to you over Zoom or over telephone. And it is incredibly informative and very helpful. So if you have problems, fill out the form. I'm going to plug that hotline again. And if you need any of this information, we're going to be sending out emails, making social media posts, so don't worry about that at all. With all that said, let's get started.
All right, that leads us to Mike.
Okay, I'm going to share a screen here, and we'll get kicked off. Can you see that, Danielle, okay?
Yep, looks great.
Okay, well, excellent. So, well, welcome everybody. Yeah, I'm glad you're here. We're going to go through this stuff fairly quickly, but what I'm hoping to do, I mean, I'm not going to make you a First Amendment expert, but hopefully we're going to provide you with enough information that you're going to know the basics of what your rights are, and you're going to have enough information, you know, if you think there is a problem, you can reach out and we can give you a little bit more one-on-one help there. Danielle kind of told you a little bit about what we do at the Student Press Law Center. One of the things I will just point out on our website page is how you actually get in touch with me and my colleague John Falk, our staff attorney here, through our hotline. As William said, you can either send us an email or you can set up a free telephone consult. We handle pretty much every media law issue that comes up. So we're going to talk about the First Amendment tonight and censorship, and really that's the reason, that's the number one reason that students continue to call us the Student Press Law Center. But we handle questions on pretty much every media law issue. So if you have questions about copyright or libel or access to records and information, I just finished giving a talk on that. You know, reporters' privilege, protecting anonymous sources. You know, pretty much any sort of media law question that comes up, we're happy to give you a hand with that. So, but like I said, today we're going to talk about censorship and First Amendment protection. I think probably the first thing that we need to do is just kind of talk about, you know, what is censorship? There is, you know, I think we can all, you know, agree that there are certain types of acts that would fall into the censorship category. Anything that we call prior restraint. And basically, that just means if you are being told by your principal, by your college president, or some other school official, you know, you cannot publish something, or if they're doing something to affect that. So they're calling the printer, you know, and telling them not to print your publication. We're not going to pay you. You know, anything like that that's just a direct, you know, an attempt to prevent you from publishing your story. That's, you know, obviously censorship that we can all agree on. Other forms of really clear censorship, newspaper theft. You know, this year has been fairly light. We haven't seen a whole lot of these incidents, but you know, most years we do see, you know, about a dozen or two attempts to just go out and just pull papers off the racks. Well, that's obviously, or damage them somehow. That's obviously censorship. And prior review. So prior review is a different category than prior restraint. Prior review is just reading only. It's insisting that you know, that you provide a copy of your work to typically a school official, so that they can read it ahead of time. The law is different in this. We have both college and high school students on the line here, and so we're going to try and distinguish between the rights that are available to most of them. But this is one of those areas for college students. Courts have said that mandatory administrative prior review is unlawful. It violates the First Amendment, so they cannot require that you submit your work ahead of time, you know, before you're allowed to publish it. Unfortunately, at the high school level, we don't have that sort of clear law that's available, and absent some sort of you know, policy that says you can't engage in prior review, typically you can. But you know, there are also ways of doing that. You know, if they take way too much time to look at your paper before they approve it and say that you can publish. I mean, we can, you know, prior review can lead to certain types of censorship that you can fight. But there's also lots of other sorts of censorship that occur, and this is kind of what I want to talk about here. All sorts of forms that aren't just directly going out and pulling papers off racks or something like that. One of the big ways that we see censorship take place is through funding. Using kind of the power of the purse to punish you for something you published, or prevent you from publishing something that you want to publish. Using that power of the purse directly to impact what you are able to publish is definitely a form of censorship. Firing editors, firing staff members for things that they published, form of censorship. For our college student media, we have lots of college publications have what we call publication boards or media boards that are typically set up to select the editors. That's typically their main reason for being in business. But we've had situations where schools have stacked those publication boards so that they get the right kind of editors on the student newspaper or student media. So that's something you can push back against. One of the big ways that we've seen in recent years of going after student media is through an advisor, particularly at the college level, where the laws really are, as we're going to talk about later, the laws really are fairly clear and fairly protective of student media. They will go after the weak spot. The Achilles heel is often the advisor. They will, there's a lot more that you can do going after an employee than you can going after a student in many cases, and sometimes that takes place. I know Adriana on the call here has a big story that just took place where she was, as an advisor, was impacted. Launching investigations against student media for things they've published, gag orders telling you that you can't talk to particular student or faculty members or other sources for your stories. That can be a form of censorship. Really, courts have said that any sort of action that's taken specifically because of content that you've either published or content that you're thinking of publishing, and where the attempt is to manipulate or censor or to control, to somehow have an impact on what you're able to publish. Courts have said they are willing to look at that. Now, the thing with all of these indirect censorship claims that's important is you have to show that content-based motivation. Simply saying that our advisor has been fired and that's censorship, that's not going to be enough. I mean, if your advisor is not showing up and doing their job, they can be fired and disciplined just like any other employee. But if they're going after your advisor, or if they're changing the funding that's going to your publication specifically because of content-related reasons, they've sent you emails telling you how much they hate what you're publishing, or they've made phone calls or something to your newsroom saying those sorts of things. That's all the sort of evidence that you'll want to collect and keep, because that's the evidence that we would use in order to claim, that they have cut our funding because they don't like our content and are trying to punish us for our content. And again, courts have said that they will, they'll look at those sorts of things. So just kind of keep an open mind when we're thinking about censorship. Kind of another preliminary thing where, there is a distinction between the rights that are available to public schools and to private schools. And hopefully I'm not going to burst any bubbles in a huge way here. This isn't going to come as a huge surprise. But when you read the First Amendment, Congress shall make no law. What courts have said in interpreting the First Amendment, Congress shall make no law, they said that requires some sort of state action. The First Amendment only restricts censorship by government officials, by government actors. For example, if you're walking down the street and you have your Save the Whales placard, and I see it, and I hate whales, so I come over and I take your placard out of your hands and I bust it over my knees. I've definitely censored you, and I've probably also, committed a criminal assault on you, but I've not actually violated your First Amendment rights because I'm a private person, and so I cannot engage in a First Amendment violation. On the other hand, if the city police are the ones that are coming and taking that placard out of your hands, they are definitely government officials, and that's what the First Amendment is designed to protect against. So always do keep in mind, kind of that distinction. When we're talking about public and private schools, it plays out, just as you would imagine. The First Amendment really is only going to be effective in preventing censorship at a public school. At a private school, we can't really call upon the First Amendment, but there may be other sorts of legal avenues that are available. If you are in California, for example, or Rhode Island, kind of the big state and the small state, those two states actually have state laws on the books that provide specific protection to private school students. There may also be some state constitutional protection as opposed to the federal Constitution, which is the federal First Amendment. But there may be state constitutional protection that might be available to you. One of the big ways that private schools can protect themselves is through policy. If you can get the school to adopt, during good times, if they will adopt a policy talking about kind of the importance of student free speech and the importance of student media, if they have made certain promises, courts have said they actually have to follow through on those promises. And if they don't, you can go after them not on a First Amendment basis, but on kind of a contractual basis. They've made promises, you pay tuition, there's a contract there. So if you are at a private school, I apologize for a lot of the stuff that's going to follow here. It's good to know, important to know. But I do encourage you to go to our website where we actually have, you can just type in private school guide. And we actually have a whole guide that kind of walks you through some of the other alternative provisions that might be available. But today we're going to talk about what sort of protections are available for students attending public schools. One thing I just want to kind of bust before we get into it all is this whole publisher myth. One of the things that we see, very often in these cases is, where, and this is probably more likely at the high school level, it seems like, than the college level, but where censorship is taking place, we will have, the principal or some other school official say, well, we have the right to censor the paper, to control the content of the paper, because we're the publishers of the paper. Really important to be prepared for that argument, because it does come up a fair share, and get ready to blow it out of the water, because it just doesn't hold weight. For the one, when you compare like the, a principal at a public high school versus, the owner of the Los Angeles Times or Washington Post or something, at the Washington Post, Jeff Bezos owns the Post. He pays the bills. It's his company. He legally owns it. Obviously, at a public high school or public college, nobody, the principal no more owns the student newspaper than he or she owns a school bus, or has the right to, hold private parties in the cafeteria. Taxpayers obviously are the ones that are supporting or footing the bills at a public school. The big thing, though, to keep in mind is that a public school principal, a public college president or other school official, they're government officials. They are government actors. And again, the whole reason that we have the First Amendment is in place is because we want to limit the ability, the authority of government officials to censor, to control what we say, how we express ourselves. So, get ready to just blow that whole publisher myth thing out of the water. All right, so we're going to kind of start, I think, in order to understand where we are in terms of, what sort of protections that we have. It's important to, get a sense for where we've come from. And pretty much every discussion of student speech rights has to start with the seminal case, the landmark case, Tinker v. Des Moines. And, hopefully a lot of you have probably talked about this. The Tinker case is discussed in pretty much every high school history book or civics book. And it really it was the first opportunity that the court had in a very direct way. I mean, they played around a little bit with the First Amendment rights available to students during the 40s, in some cases involving the right of students not to have to stand to pledge allegiance to the flag. But it really wasn't until the Tinker decision, which was handed down in 1969, that the court was, had this opportunity to directly answer the question, what protection, if any, what sort of First Amendment protection do students have when they're in school? The case came about so the Tinker family, Mary Beth Tinker, who's pictured here, and her brother John, who's not pictured, but they were the primary movers in this case. But the Tinkers were actually they were a family that was very much involved in the anti-war movement. The dad, Mr. Tinker, was actually a Quaker minister, and he and Mrs. Tinker had been very, very involved in the civil rights movement. In fact, they'd gone down to the South and taken part in some of the voting cases down there, but they were very much part of this whole the peace movement. And John Tinker, so John Tinker was Mary Beth's 16-year-old brother. He was, I believe, a sophomore at the time. And this case started in 1965. So in 1965, John Tinker, along with some other members of their church group, actually went back to Washington, D.C. To attend the first peace rally, the first anti-Vietnam War rally. 1965 was a really important year in the Vietnam War. It really was the first year that kind of the Vietnam War came onto the front pages of our newspaper. It really started to get attention. I mean, the numbers of casualties and the kind of just the amount of military effort had really escalated around 1965, and so this first peace rally was a big deal, and it had a really big impact apparently on John Tinker. When he was there, on their way back to Des Moines, Iowa, which is where the family lived. They were in their van coming back from the rally, and they talked about, this is a really big deal. How do we bring this message back to Des Moines? And so the thing that they settled upon apparently in this van ride is that they decided they were going to wear these black armbands to school to protest the Vietnam War and to mourn those that had died in the war. And so they decided on a day in December in which they were going to wear the armbands to school, and a couple days before the day that they were planning to wear their armbands, a student newspaper in Des Moines, a high school student newspaper, actually published a story. They got wind of this protest that was going to take place, and they published a story, basically kind of cluing the district officials in to the fact that this was going to take place. They ended up calling an emergency meeting, again, just a couple days before the protest, at which they passed a rule that said, students cannot wear armbands to school. And so all the Tinkers and Mary Beth in particular, had a decision to make. This was now going to violate school rules. It was going to just be a peaceful protest, but now it's going to violate a rule that they just passed. And so they all had to make a decision. Mary Beth talks about how the morning that they were planning to wear the armbands to school, she used just that little bit of courage that she had to go ahead and go forward with it. She talked about how she was just a very good student and never gotten in trouble, so this is a really big deal to her. But she used that little bit of courage she had to actually wear the armband to school. She talks about how pretty much half the day went by and there was not a whole lot, not much came about of her wearing the armband. She said a couple of her classmates came up and asked her, what's the armband all about, Mary Beth? And so she explained it. But for the most part, it was just an average school day. It was when she was leaving lunch and going to her math class that she was met at the door of her math class by her teacher that handed her a pink slip, which she still has actually, and said, go down to the office. And so she goes into the office and she's told by the receptionist there, Mary Beth, there's a rule against armbands. You need to take that off. And so she ends up taking it off. She said that's the point at which her little bit of courage ran out. And so she talks about how she was walking back to class and she was just so relieved and proud of herself. Honestly, she had used that little bit of courage and she'd done what she wanted to do, and that was the end of it. Well, obviously, that was not the end of it. It became a very big deal. She was called in later that day by the principal, who said, Mary Beth, there are consequences for breaking school rules. And so she, along with her brother John and other students who had worn armbands to school, they ended up being suspended And it became a big deal. I mean, the Tinkers tried to work with the school board to have the suspensions rescinded. The school board is having none of that. Again, the Vietnam War was becoming a very polarizing sort of topic. They had some school board meetings that apparently got very, very heated. There were actually death threats made against the Tinker family, and there was paint thrown, in the direction of the Tinker's house. So it was a really big, sort of thing at the time. And neither the school board or the Tinkers backed down. And so they ended up going to court. And the case made its way up through the court system all the way to the United States Supreme Court. So this was in 1965 that this all took place. It was about 3.5 years later, 1969, that the Supreme Court had this case before them. And the Supreme Court ruled for the students. They said that neither students nor teachers shed their constitutional rights to freedom of expression or speech at the schoolhouse gates. In other words, students are citizens. They are protected by the First Amendment when they're in school. Now, it was not a unanimous decision. It was a 7-2 decision. The dissenters definitely had some real issues with kind of tying the hands of school officials and telling them, you have to allow this sort of expression to take place. And so they came up with kind of a balancing test to determine, when it is this sort of expression is going to be prohibited or is going to be allowed. And basically what they say under the Tinker standard, is what it's called, is that student speech is going to be protected except for in 2 circumstances. The first sort of speech that's not going to be protected is speech that invades the rights of others. Basically what lower courts have interpreted that decision, that language to mean is that it doesn't protect what we call unprotected speech. And as we'll talk about in just a minute, that wasn't a big surprise because unprotected speech is unprotected. The second category of speech, however, that was unique to students is that the court said that students also don't have the right to engage in speech that creates a material and substantial disruption of normal school activities. All right, so we'll go through each of them here. So unprotected speech. Again, lots of these should not be shouldn't be a whole lot, very surprising to most of you. And for those of you that are in journalism class, hopefully you've talked about a lot of these things, but there are just certain categories of speech that, under the law, we have decided are not worthy of First Amendment protection. In many cases, we've made that decision because this sort of speech really does not add much to the whole marketplace of ideas and that whole civic discussion there. For example, so defamation, libel, and slander. Libel is the publication of a false statement of fact that seriously harms somebody's reputation. So you're providing false information and it does serious harm. We've just decided, as a society, that sort of speech is not going to be protected. Invasion of privacy, copyright infringement, speech that's advocating illegal drug use, at least in the school context. Again, there's a number of categories of speech that neither you nor I or anybody else has any sort of right to engage in. So not a big surprise there. But the second category was new, and so we kind of have had to figure out exactly what that material and substantial disruption category means. Lower courts in interpreting that standard have generally said that in order to show that material and substantial disruption, school officials have to show a fairly serious physical disruption of normal school activities is taking place. Probably the best way to illustrate that is to kind of provide an example. And we had one a couple of years ago for many of you probably remember there was a number of protests that took place around the March for Our Lives movement, the gun violence, the anti-gun sort of movement that was led primarily by students. But during the time, a number of schools across the country, they engaged in class walkouts to support kind of the movement's efforts to limit gun violence. And we got a number of phone calls during that time. Calls came in from students saying, hey, we understand that this protest is going to take place. Can we run a news story about it? Can we publish, what this is all about? And for the most part, yes, the answer was yeah, as long as your, story is accurate, as long as it was, fairly neutral and just explaining what the whole protest was about. Yes, you had a right to publish a news story about it. That wasn't going to be substantially disruptive. disruptive. But then they would ask the second question oftentimes, can we write an editorial that encouraged our classmates, to engage in this walkout? Hey, next Tuesday at noon, there's going to be a class walkout. We think it's a worthy cause, and we encourage you to take part in it. That would be the sort of speech that, because it would be encouraging students to get up and walk out of class during the middle of the day, that's going to, impact normal school activities. It's going to cause a serious physical disruption to normal school activities. And so that would probably be that sort of editorial encouraging that sort of, action would probably be something that would meet that material and substantial disruption test, and probably could be censored by school officials if they wanted. The second part of the material and substantial disruption test is that school officials have to have a reasonable forecast of disruption. They can't just have this hunch, I just think if you run that, it's, something bad is going to happen. No, courts have said no, there has to be kind of a showing that, that the speech, such as the editorial with the March for Our Lives, they're given specific time frames. They're encouraging students to walk out. It's probably a pretty good, you could probably make a pretty good forecast that students are actually going to follow through and actually, get up out and walk out of class. So that's the second part of the Tinker standard there. Now, the Tinker standard really did change things. I mean, it really is important to understand just the impact that decision had. Following the Tinker decision being handed down in 1969, there were that was kind of like the late 60s into the early 70s was when we saw a lot of student protests taking place. Particularly on college campus at the time, that were against the Vietnam War. They were out in large numbers, and it was because of the Tinker decision, saying that students, when they are on campus, are protected. Their First Amendment rights are protected. It was the Tinker decision that actually, was the reason that they were protected in those cases. I will say that a few years back, there was a number of historians and civil rights people that got together. They named their 101 change makers, the rebels and radicals who have most directly impacted, changed U.S. history. And John and Mary Beth Tinker were actually on that list because their case really did change everything. And I'm happy to say that they're out. They continue to spread their message today across the country. One of the things they did a few years back, they went back to Mary Beth's junior high school, and they actually had they named the day the Tinker Day, and they actually rededicated her locker as a First Amendment locker at the school. So, again, just using that little bit of courage, you can affect powerful change. So from 1969 to 1988, Tinker was the law. So, anytime any sort of case came up that involved student speech rights, student expression rights, Tinker was what courts looked to for guidance in determining whether that speech was protected or not. Tinker was cited in cases involving student newspapers, student media, student yearbooks, but also, student theatrical productions, or just, handing out flyers on their own on campus. Any sort of student expression, Tinker was the law that was always going to be cited, and it really was pretty much the case for student journalists until the Supreme Court had its next opportunity to take a look at what sort of rights students have. And that case came down in the form of Hazelwood School District v. Kuhlmeier. Again, probably a case that a lot of you guys have maybe talked about or heard about. The case took place just outside of St. Louis, Missouri, at Hazelwood East High School. Hazelwood East High School had a student newspaper that was actually edited by one of the folks on our call tonight, Cathy Kuhlmeier. Here she is back in the day. But Cathy, they put out a paper called The Spectrum. And when you talk to Cathy, she'll tell you, that there was a lot of frustration on the paper when she came onto it. They were mainly doing a lot of kind of rah-rah stories and, talks about, stories about high school football games and school dances and things like that. that, and they were frustrated. They wanted to change that. And so when she came on board, one of the things they decided to do was to put together kind of a special edition that focused on some of the contemporary problems that they thought, most affected teens in the early 80s. So this took place in the very early 80s, 82, 83. And a couple of things they decided they were going to cover was teenage pregnancy. And they also did a little piece on the impact that divorce had on students. But the teenage pregnancy piece in particular was one they spent a lot of time on. I mean, the people that wrote the story, they interviewed mental health counselors and medical people. They talked to school officials. They talked to a number of students at the school that were pregnant. And so they spent, my understanding is several months putting this piece together. And then before it was scheduled to come out, a thing came up that kind of changed everything, I think. They actually had a change of advisors. Their old advisor, who had been with the Spectrum for many, many years, he decided to leave. He had another opportunity and just said, I'm going to take this opportunity. And so it didn't really have anything to do with the school, with the student newspaper itself. It was just something else that had come up. But in this advisor's place, they brought in another advisor. And this advisor came from a school where it was their policy to provide copies of the paper to the principal prior to publication. So they voluntarily allowed prior review of the paper. And so this had never been done at Hazelwood East, but it was done in this case. And the principal, apparently, when he got the paper, I think when you read some of the depositions, the only way to describe it is he freaked out. He just felt that, these sorts of topics, particularly teenage pregnancy, was one of those topics that was simply not appropriate for a high school student newspaper. Now, that is despite the fact that, as Cathy will tell you, they actually had a daycare at Hazelwood East High School for pregnant students. But the principal said that this is just not an appropriate topic for discussion. There's Cathy again. And so the case works its way up. So once again, just like in the Tinker case, they tried to resolve it at the district level, but the district wasn't backing down. Now, it's important to remember, in 1983, when this handed down, Tinker was the law, right? So under Tinker, what you should do in these cases, you would read the article and say, is there anything in the article that's unprotected speech? Is there any libel or invasion of privacy? And the answer to that is no. It was a legally clean piece. The second part of Tinker is that, is this the sort of article that would create a serious physical disruption of school, material and substantial disruption? And again, the answer is no. I mean, students are probably going to read this piece. It would be different from the sort of work that they'd usually seen in the Spectrum. But, it wasn't the sort of thing that was going to, result in class walkouts or fistfights or anything like that. And so, under Tinker is actually a really easy case. And I will say that the appellate court, the Federal Court of Appeals that heard this, said exactly the same thing. They basically came down with the decision that said, hey, under Tinker, this is easy. It's just protected speech. It's not disruptive speech. It should be protected. And so we'd hope that would be the end of it. But the school district decided to appeal to the Supreme Court. And the Supreme Court, surprising to a lot of us, because we thought the law at the time was quite settled, but the Supreme Court decided to take the case. I think a big part of the reason was, the makeup of the Supreme Court had changed fairly significantly over the time. It had become, a lot more conservative. The court ruled against Cathy Kuhlmeier and against the Spectrum. Now, they did not, in handing down their decision, they did not overrule the Tinker case. They said that Tinker is still good law, but they said that these cases are different. In the case of Mary Beth and the Tinkers wearing their armbands to school, they had made these armbands up on their own. They'd sewed them together as a family, and they'd made the decision to wear the armbands, all entirely independent from the school. On the other hand, the court said, the Spectrum was school-sponsored speech. It was part of the curriculum. There was a school-funded, the school paid for most of the printing bills. It had a faculty advisor that was paid by the school. and they said that because it's school-sponsored speech as opposed to Mary Beth's non-school sponsored speech, a different standard was in order. Basically, the Hazelwood standard says that school officials can censor anytime their censorship is reasonably related to a legitimate pedagogical concern. Pedagogy is just a simple way of saying, was there a reasonable educational justification for the censorship? In order to censor, they had to show that the school officials had to show there was a reasonable educational justification. Well, what does that mean? Well, we had no idea really exactly what that meant. We did know, however, that where Tinker provided a fairly significant barrier to censorship, Hazelwood was going to be much different than that. The court actually gave some examples of what they felt would constitute a reasonable educational justification. And they said, and you can see in the slide here that these are all in quotes because this is language taken directly out of the Hazelwood decision. They said that school officials could meet that standard as long as they said that an article was, quote, poorly written or biased or prejudiced or unsuitable for an immature audience, which is, what the principal at Hazelwood East High School said. My favorite, though, is one at the bottom. And this is something that is a First Amendment lawyer, we had never, ever seen language like this in a First Amendment case. But they said that school officials could censor student speech, where they showed that material was, quote, inconsistent with the shared values of a civilized social order. I mean, hopefully all of you all are just saying, my goodness, you're just like, what the heck? And that's certainly what, most of us that worked in this space felt as well. We'd really never seen a case like this, except for the year before. The year before, the Supreme Court had handed down a decision where the question was, what sort of First Amendment rights do prisoners have? What sort of authority do prison wardens have when it comes to censoring that speech? And when you look at the language of that case, you can see that, that the Hazelwood court took a lot of that language and simply, changed a couple words. So prison wardens are allowed to censor prisoner speech when they show that their censorship is reasonably related to a legitimate peniological interest, whereas principals have to show a legitimate pedagogical interest. So it's important to know kind of where your rights come from. So one big question, since we do have some college students on the line here, is how does Hazelwood affect college student media? Well, there was a footnote in the case, footnote 7 in the case, which said that we need not now decide whether the same degree of deference is appropriate with respect to expression at the college or university level. So we dodged a bullet. I mean, we at least in that particular case, they were not saying that this is, Hazelwood is the law and Hazelwood applies to both high schools and colleges equally. They were reserving that question for a later day. So it was good news in the fact that they weren't immediately saying that this horrid standard is applicable to college students, but they also left that question open, and so we were waiting, and we were waiting for that first challenge, and it actually came. It took a while, but the first changes came about a dozen years later. There were a couple cases before this one on the screen right here, where we faced the question, and in all those cases, the courts thankfully ruled on the side of the college students. They said that there is a distinction between college expression and high school student expression, and that there should be a different standard applicable to college students. But there was one case, this Hosty v. Carter out of the 7th Circuit, which covers schools in Illinois, Indiana, and Wisconsin. And basically what happened there was a student newspaper that was really getting on the nerves of some of the school officials there. And at some point, one of the school officials called up the printer and said, you are not to print any more copies of this paper until somebody from the college, so a college official comes down and actually approves it. Well, obviously, that's the sort of thing that had never been allowed before. And so the students went to court on that. And they did win the case. They ended up winning the case, but not before the court said that, Hazelwood is the starting point for looking at college student censorship cases, at least in Illinois, Indiana, and Wisconsin. So we do have, a case on the books that suggests that this Hazelwood standard might even be appropriate for college students. students. But that's really, it's kind of the only decision that's out there. And I do want to make sure that I don't leave you with the impression that that is the law, because prior to the Hosty decision being handed down, we had, in excess of 60 different lower court decisions where college student media was provided with significant sorts of protection, First Amendment protection from any sort of censorship. More indicative of where the law is today, I think, is like this case from 1986, where they said that, a campus newspaper at a state-supported university is entitled to the constitutional protections afforded the press, including freedom of expression for editors. At the public college level, it really is a hands-off stance that school officials have to take. Again, for whether it's direct censorship or indirect censorship, more likely it's going to be indirect censorship at the college level, just because the protections really are very strong for college student media. But yeah, it's basically just a hands-off policy. School officials have to keep their hands off college student media. So one of the results of Hazelwood, we knew that calls would go up to our center, and they definitely did. We saw between 1988, when we at the Student Press Law Center were getting about just over 500 phone calls to our legal hotline. Over the next 10 years, that number had almost quintupled. We got close to 2,500 calls from folks asking for our help. So it was bad news. I mean, there's really no sugarcoating Hazelwood. It was a terrible decision, but it doesn't, and school officials definitely took it to heart, thinking it was this unlimited license, but it's not. It's really important to understand that there are some limitations to Hazelwood. First of all, it's not going to apply in almost all cases at the college level. That's the main thing I want to leave you with. But it also doesn't apply to school-sponsored speech. Again, remember, Tinker still remains good law. Tinker applies to non-school sponsored or independent student speech. Hazelwood doesn't. In 1988, when the case was handed down, it was pre-internet, right? So, I mean, the student newspaper, the print student newspaper, was one of the few ways for students to actually get their message out. The only one of the few places they could say what they wanted to say. You could write a letter to the local editor of the paper or something, but it's up to them to publish that. But a student newspaper really was one of those places. So, censoring a student newspaper was a really big deal. But hey, it's 2022, and in 2022, unlike 1988, there is a lot of non-school sponsored expression available out there. I mean, any sort of social media sort of speech that takes place. We just had a good decision come down this past year, the Mahane case, the F-cheer case that some of you might have heard about, but it made clear that, again, that off-campus expression, using your own social media accounts to post, the things you want to say, is going to be protected. So, we have a lot of different avenues that are available, and I give, one of the things that it's changed the way I give advice. I mean, before, if a print paper was censored back in the early 90s, we had to fight tooth and nail to make sure, that we fought back against that censorship, because it was, the print newspaper is the only game in town. Today, we will give the school officials a bit of leeway, but if they simply are not willing to listen to reason, not willing to, hear students and their objections to the censorship, there's lots of places that we can go to get the story out there. And we do that all the time. So. Hazelwood also doesn't apply to student media that qualifies what we call public forums. We don't have enough time to really go into a whole discussion of what public forum doctrine is, but basically, if there is a policy or practice in existence that is historically provided students with the right to make their own decisions, then they would qualify as a public forum, and Hazelwood would not apply. Hazelwood standard also has some teeth. I mean, as we talked about, I mean, there's a lot of leeway here, a lot of, school officials have, considerable leeway when it comes to going after student media, but it still does have some teeth. I mean, Hazelwood says that school officials have to have a reasonable educational justification in order to censor something. They have to show that. They just can't say, we're going to censor it, we're not going to provide you a reason. They have to have a reasonable educational justification. And we've actually had some really good cases out there where courts have said, hey, they haven't met that standard. And particularly what they've looked for is this good journalism? If it's good journalism, if it's the sort of journalism that local newspapers would publish, or journalism professors say is, it's ticking all the boxes in terms of, how you've actually put the story together and reported the story out. Courts have said, that doesn't meet the Hazelwood standard. And so you can push back on that as well. The other thing, though, that we'll kind of finish up with here is, state laws and local policies can also effectively nullify pushback against Hazelwood. So again, Hazelwood is a First Amendment decision, and First Amendment is based on the Constitution, the U.S. Constitution. Each state in the country can always, as a state, you can never pass a law that provides less protection than that provided by the First Amendment. So think of the First Amendment as providing like this floor of protection. You can never pass a law, pass a policy that provides less protection than that provided by the First Amendment. But you can always pass a law or a rule that provides more protection. And that's what's happened. Yeah.
Hi, it's Danielle. I'm going to cut in for a moment before we get to new voices, since it's a really important point. Because as you mentioned earlier, we have Cathy Kuhlmeier here on the call. So I chatted with her separately, and she said she'd be willing to say a few words if you don't mind us sort of cutting in for a moment.
Absolutely. That'd be awesome.
All right. Let me...
Should I stop my show here?
Yeah, I think that works.
Okay.
Hi, Cathy. Thank you so much for joining tonight. It's really great to see you.
How's everybody?
Hey.
Great.
Hi, Mike.
Hey, Cathy.
Hi, Hadar.
So I've had the pleasure of hearing you speak a couple times over the years. I wonder if you might talk about, why you're joining this call tonight, why student press freedom is still an issue that's sort of near and dear to you, and if you could maybe share the story of your own child going through a censorship situation.
This is still important to me because it's still a relevant fight to be in, because it's still happening. My son is now a college graduate, but during his junior year also of high school, he was censored in his school. They had written a story about a rite of passage, essentially, and they were talking about a water gun game fight called Assassins, and it's a strictly an off-campus game that's played, and it's only for seniors, so it just gave the who, what, when, where, and why. So it's a senior game. You pay $1, you get to get a target, you play off campus, and whoever is the last person standing wins, essentially. And the new advisor, there's so many things that mirror what happened to me. New advisor, new principal, junior year, all of this starts. And they said that they weren't going to run the articles. And my son came home and he was upset, and he was like, trying to explain to me what's going on. And I said, what do you want me to do? Being that good mom, trying to mama bear coming out. And he said, I want you to talk to the teacher. So the following day I called and I talked to the teacher, and my son had been in the class working after school, and he answered the phone and handed it off to the teacher. Now, background on that, prior to this ever happening, underneath the prior advisor, I would go in every year and talk to the class and let them know, tell my story about what went on. And so the outgoing advisor told the incoming advisor, hey, you kind of got this resource in your, in your back pocket. And, she comes in and talks to everybody. So she knew who I was. So when I called that day, I said, hey, this is Eric's mom. I said, I just wanted to try and understand what was going on, why those articles didn't run. She goes, what business is it of you to know what's going on in my class? And I was like, well, my son's in your class, so it's kind of my issue. And then I said, so why did you not allow the article to run it? She said, well, who are you to know anything about First Amendment? And I said, well, let's review. And she said it promoted gun violence. And I said, so how many people have actually died by water gun death? She didn't like that, but I've always been that kind of challenging individual. I challenged the principal back in the day of my own issues, but this is why we still talk about it, because things like this are still happening across the country, not just in Missouri, although it seems to be a hot plate for it. But it shouldn't be like that. That shouldn't be the climate for student journalists to go to school and worry about being threatened that they can't run things, or that his particular advisor went on to tell the kids that if they try to pursue this any further, that she would either take away any of the letters of recommendation she had written for college applications, which was a big deal because the kids obviously need, everywhere needs any kind of help you can get for financial aid and scholarship. And then she told my son, who was to be the editor in chief the following year, that if you continue to push the issue, that you won't be the editor in chief. And that's not what it should be. This should be a safe place for students to go to, regardless of the school, to be able to talk and express their beliefs, talk about things, respectful conversations, and to learn to see if this is really the right career path maybe for you down the road. But it's got to start somewhere. And so the problem is that kids are self-censoring themselves, and that's not the environment that we want to be in. We've also learned that advisors are being threatened with tenure or losing their jobs. And that's not what this is about. It's about getting things right, allowing the freedom of speech so that we can grow and stop the self-censorship and make amends with things. And that's why we have the new voices, that we will just continue to fight it at a state level to get new laws passed and to continue the movement to overturn those laws and give the rights back to students where they belong. So that's my little plain story.
Cathy, continuing to fight. Thank you so much. It's always awesome.
Absolutely.
Seeing you. Yeah.
Hey, Mike.
Thank you so much. I will throw it back to Mike, but if you do stick around to the end, maybe if anybody has questions, we can chat during Q&A.
Of course.
All right, back to you, Mike.
Thanks.
All right. Okay, are you seeing the right screen there?
It's not full screen yet.
Okay, we good there?
Yep.
Okay, so yeah, we were talking about, one of the ways you can push back against some of the censorship is to find help at your state level. To date, so I will say that the reason this came about is way back in 1977, way before even the Hazelwood case, California had passed this law, which essentially had codified the Tinker Standard, basically saying that students have the right to speak out unless their speech, creates a serious and material disruption, or is unlawful in some other way. And so California had this model law in the book. So when Hazelwood actually came out, California, wrote to its different schools and say, hey, we are aware that this, new Supreme Court decision came out that's really cutting back on the First Amendment rights of student journalists. But here in California, we're really not impacted by that decision because we have, this independent, this separate state law that provides our citizens, our states, our students in our state with additional sort of free speech protections. And so that actually, before the Hazelwood case came down, that law really hadn't been used a lot. But after Hazelwood, it took on a whole new significance. In a number of states using the California as their model, started passing what we first called anti-Hazelwood laws, because that's the specific reason they were passed, but which we now call New Voices laws. Massachusetts actually was the first state in the country to pass one of these New Voices or anti-Hazelwood laws in 1988, the same year that Hazelwood came down. And since that time, we've had 16 other states, or 15 other states, I guess, pass these laws. We now have 16 states total that have passed laws that provide specific protection to student journalists. You see there's a little asterisk there. 10 of those states actually provide specific protection to college student journalists. So in the wake of that Hosty decision out of Illinois, out of the Seventh Circuit, we've added protection for college student media to these laws. But basically, the way that these laws work, and if you do take a note and see if your state is on the list there, but the way that these laws work, every one of these laws definitely provides some protection for high school students. students. In effect, what they do is, again, they kind of turn back the clock and they say that, Tinker rather than Hazelwood is the standard that's going to be applicable here in our state. And so high school students are always going to be protected. 10 of those states actually protect college students, and 2 of those states, California and Rhode Island, actually protect the rights of private school students. A number of the states also protect, the laws also protect, have provisions in it that give liability protection to the school districts. So, as long as only students are the ones that are making the content decisions, as long as school officials really are exercising kind of a hands-off policy, these laws say that the school district cannot be held liable. Their deeper bank accounts actually won't be available for somebody that's suing as a result of something that might have been published in student media. The other provision that is in a lot of the laws, not all laws, but most of the laws, have provisions that protect advisors from being retaliated against or fired or disciplined, for standing up for their students. And Adriana is on the line here, who just had a big case take place down in California, Daniel Pearl. She maybe will also stay on the line after and answer some questions. If you cannot get a law passed at the state level, you can get one passed at your local level. So, for high schools at the district level, college students can also, have their board of regents or something pass a law that protects laws at on a more local basis. But those have the same sort of legal authority, same sort of legal weight as a state law would have. So what do you do if you get censored? The main thing, and there's a whole long list. We have, obviously we've gotten pretty good at this over the years. We have a whole, once you call me with a censorship question or censorship issue, if we're going to fight that censorship, there's a whole checklist that we start running through to get you up to speed. The main thing, though, that you can do to protect yourself is just to practice good journalism. Making sure that the stories that you're reporting are well written, well reported, well sourced. Being able to publicly stand up and defend your journalism is the most important thing that I've seen in all these cases. So just doing good, solid journalism. If you're willing to stand up and fight back against that and stand up and defend that, there's going to be a place. There's going to be a place that your story is going to be reported out. Last thing is know your rights, and hopefully, after this presentation, you can put at least a small check mark next to that one there. So, but that's it. That's all I have to say here. Danielle, I'll end my screen here and bring us back online.
All right. Thank you so much, Mike. As always, you're so great at this. Like I said, we have a couple minutes here to talk about Q&A. So I have at least one question lined up, but if you folks are thinking of other questions, you can either drop it in the chat or go ahead and raise your hand here on Zoom and we will get to a couple of them. We're only going to give it about 10 more minutes because we are at 8:30 already. Time absolutely flew, and I want to respect everybody's time. But if you have additional questions, you can either send them along to us, contact the hotline, you know the deal. So let me look. Our question I have lined up was someone had asked if you could clarify when we're talking about public versus private, where do charter schools factor in?
Charter schools are typically going to be considered public. A number of I think most of the states that I've seen that have ruled on that issue have said that yes, at least for purposes of free expression sort of rules, that charter schools are going to be considered public.
Awesome. When it comes to new voices, if someone is in a state that doesn't have a new voices law, what can they do?
One of the things they can do is, like I said, if you think that there's any chance, for example, like your school district, if you have a school board that might be open to, the idea that, hey, student journalism is important, and instilling in our next generation kind of, an appreciation for a free press and a First Amendment. If you can find allies on your school board that might be willing to, adopt a local district policy, those work just as well, honestly, as a state law would work. So that would be one way of doing it. Lots of other things. One of the good ways, I think, of kind of protecting yourself, insulating yourself, is, before you have a problem, to maybe bring in some local media, go out and talk to, your local editor, your local reporters for the TV station, invite them into your newsroom, let them, see what you're up to, see what you're doing. So, when you do have a problem, you have, kind of a natural ally that's available there to push back on. The other thing I will say is that, if you have not started an alumni list, some sort of alumni group for people, for former staffers, do so now. I mean, that having just a Facebook page or something like that, a Facebook group where you can go, where you have a censorship problem, being able to alert people, that have been where you are, that have a vested interest in kind of pushing back and being an ally. That can be also very, very helpful.
Excellent advice. We have someone, Jamie, who says they have a follow-up. Jamie, do you want to go ahead and chime in?
Hello, Jamie here. So my follow-up question to that is, like, what do you do if you're struggling with like censorship or like questionable censorship, which I know my publication has been struggling with this past semester, but we don't have a faculty advisor. Our advisor to our organization is just like a general like student advisor, like a general like student organization advisor. Like, she oversees multiple organizations. We don't have a media board at our campus either. My fellow media president at the second media group here on campus are working on creating a media board for our campus. So it's like we don't have a faculty advisor, we don't have a media board. Like, who do we go to, or what can we do if we don't have some of these boards? And we're also in Ohio, so we don't have like that one law that we were just talking about. We don't have that either. So it's like
Yeah, so I think you're right state, is that right?
Yes.
Okay, so you are at a public school, and I hope that I wasn't too it wasn't too confusing, and just you're reminding you folks of the difference. There really are significant differences between the First Amendment protections that are available for high school students and those that are available for college students. At a college, and definitely in Ohio, you have very strong First Amendment protection. I mean, basically the law says that school officials really do have to have a hands-off policy when it comes to the student media. Now, obviously, there's they can make lots of efforts, and it sounds like maybe that might be some of the things that's happening to kind of go around the law and to kind of skirt some of those protections. But the bottom line is those laws do exist, and they do provide protection. So you can push back, and in most cases you'd win your case. In terms of some of the other sort of things like getting a media board, yeah, those are all things that can be very, very helpful. I mean, I don't know, you do have a fairly strong scholastic press press group in Ohio that you might want to reach out to, just to let them know kind of what you're up to. But yeah, and just keeping me on speed dial, keeping the SPLC on speed dial if you have specific questions that come up. I know we've talked before, so.
Yeah. Got it. Great. Thank you.
Yeah.
Thank you so much. All right. I think I saw William's hand up.
Yeah. I just wanted to, sort of make a point, but also clarify something. So Hazelwood versus Kuhlmeier, like, it says that if your publication is an open forum for student expression by policy or by practice, that those censorship rules don't really apply to you, like beyond Tinker, right?
Correct.
Okay. So I think like there's a question earlier about like, how do you deal with this sort of censorship if you don't have a New Voices law, stuff like that? Like, if you're operating in peacetime, let's say, because usually the censorship happens in an instant when the school board like sees something that they don't like, as opposed to it's a ongoing process. That's oftentimes the case. And so when you're in peacetime, make sure that you've got editorial policies that say you're an open forum for student expression, that you by practice also operate as an open forum for student expression. That qualification is going to get debated if it ever proceeds to some sort of legal action. But if you operate that way, you give yourself a little more ground a little more of a foundation to stand on with regard to Hazelwood, which is, you know, the dominating case with regard to these issues.
Yeah, no, good point. And you know, if you can't get your school board to pass, you know, enact a specific student media policy, doing exactly what you said, you know, putting something in your masthead or something on your website, you know, that this self-describes your publication as a public forum for student expression. That can be helpful. And like you said, I mean, the longer that your media organization operates in that way, you know, the longer that you can show that student editors have in fact, you know, been able to make their own editorial decisions, that also, yeah, the longer you can show that's been the case, the harder it's going to be legally for school officials to get over that hump and to actually censor you. So yeah, good points.
Thank you so much. Anybody else have any questions? I think we are about at time. First of all, wanted to say a quick shout out to our friends at JEA. We have Veronica here. I don't know if you wanted to say anything, but I just wanted to acknowledge another big person here in the room. Veronica is the new executive director of the Journalism Education Association, who advisors you all hopefully certainly know about, but the students I think may not be quite as familiar. We have lots of really great partners for Student Press Freedom Day, and so it's lovely to see you all here. I believe that takes us to the end. So thank you everyone for sticking around. It was really great. Thanks again to Mike for leading us through this discussion. Again, if you're ever in need of censorship help or media law questions, definitely contact the legal hotline. We will be sending around a email that has both the recording for this, and then also all the links that were mentioned here tonight. So for anybody who has friends or students who weren't able to join, you're able to circulate that as well. Stay tuned. We have a lot of other really fun Student Press Freedom Day programming coming down the line. And again, I must plug social media. It's really one of the best ways to stay on top of all of the really fun things that are going on. All right. With that, I'm going to bid you all good night. Thank you again for coming by.
Bye, everybody.
Bye, everyone.